So what exactly are the powers that the President of the United States has? What are the things he can do unilaterally? What are the limits that the U.S. Constitution places on the President? And why might that be a good thing? And how has this been dealt with in the past? We're going to dive into all those things in the context of two important indictments that were recently dismissed. The judge dismissed these, he closed the case, game over. The federal government cannot prosecute these individuals for now. I'm your host, Attorney James Betzold, and this is the Prima.Law podcast. Now, as always, we're sponsored by Prima.Law. That's immigration case management. We are a legal case management platform specially designed with additional features for immigration attorneys, so we can really bring out the best in immigration attorneys, helping them serve their clients better by accepting online payments, using a client portal, sharing that checklist directly so your clients can share those secure documents in a very secure manner. Find a free 15-day trial at Prima.Law. That's for immigration attorneys and immigration professionals. Let's start the show. Okay, so we're talking about the United States versus Letitia James and the United States versus James Comey. Let's give a little bit of background on first Letitia James. So Letitia James was the Attorney General, so the Chief Attorney of the state of New York. And when she ran for that office, that's an elected office, she promised she was going to get Trump. And by golly, she did. She sure got him. She got him good. And the Republicans and conservatives will say, hey, this is really an example of lawfare. And it's actually not coming just from Republicans and conservatives. Even some people on the left who practice in real estate in New York and say, hey, everything he was doing, we do. Everything, it's like standard practice what they're doing. Yeah, if you've got a building, you might pad those numbers a little bit so you can achieve more of it. You can get better terms on a loan, or you can get more of a loan from a financial institution. And these financial institutions are not idiots either, right? You know, if you've ever purchased a home, you know they're going to send out someone to do an appraisal. They're going to make sure that they're comfortable with loaning you money based on the assets that you pledge. Okay, apparently it's common practice in the New York real estate game. So was this actually lawfare? Was this an unfair attack against the former president that a vindictive New York Attorney General was doing in order to become more popular herself? That's for history to decide, but it kind of looks like it. And she did. She won. She made him pay. She secured a judgment of over $400 million, which he had a problem coming up with a bond for when he wanted to appeal that decision. Okay, and that I think that case is not completely finalized either, still playing out. But as far as that goes, that led the Trump administration to target Letitia James. We all saw the tweet that went out. I don't know if it was a tweet or on X or on Truth Social, where Trump was calling out Letitia James, and he was talking to Pam Bondi saying, hey, you know, she's the U.S. Attorney General. We need to go after these people. They're all guilty as hell, et cetera, et cetera, et cetera. All right, so we saw that happen then. Shortly thereafter, right, they found a prosecutor. Well, they couldn't find a prosecutor. They appointed a prosecutor, and eventually she was tasked with the job of securing an indictment against Letitia James, which she did, apparently. And so then that began the criminal case against Letitia James, the current Attorney General of New York. Okay, now that case is being dismissed, and we're going to go into the reasoning behind that. But first, let's give you a little background on the other case we're talking about today, U.S. versus James Comey. Now, James Comey was the former head of the FBI, and he had a little bit of a sordid past with the Trump administration, right? We all know there was a dinner where Trump wanted him to pledge loyalty. We all know that there was a lot going on with the Russia investigation, right, where there was an investigation against Donald Trump, who was a candidate, I believe, at the time. But let's see if we can understand just briefly why he's so upset, right? We know that James Comey was investigating the 2016 elections to see if there was Russian interference. And then there was a whole thing about this fake dossier that was created, and they used it like it was real evidence, and it led to a long investigation, and people's phones were tapped. And it was a big, messy situation. And turns out, yeah, that the Steele dossier was completely made up. It was fraud. It wasn't actual intelligence. And it was just designed to make the president look bad. Now, that being what it is, Trump was actually upset because Comey was investigating 2016 election interference. Trump wanted him to say that Trump, was not a target of the investigation, but Comey wouldn't do that publicly. Donald Trump asked for James Comey's loyalty, and instead, James Comey said, I will be honest with you. Of course, nobody should need to pledge loyalty to a presidential candidate, or whatever. We should pledge loyalty to the country, loyalty to the Constitution, and honesty. But that didn't sit well with President Trump. We know that Trump fired Comey in May of 2017. Comey gave his personal memos to a friend who leaked them to the press, which led to another 2-year investigation against the Trump administration. And so Trump and his allies viewed this as a calculated political hit job by a disgruntled former employee using classified or sensitive information to damage the presidency. That's how they see it. Now, he didn't use classified information to damage the presidency or anything like that, but that's how they took it. Okay? Now, what they actually indicted him on, again, this was by an attorney general who was appointed temporarily in the Eastern District of Virginia. We'll get to her in a minute. But the specific allegations against James Comey were simply that he lied to Congress during September 2020 testimony before the Senate Judiciary Committee. And specifically, they claimed Comey testified that he had not authorized leaks to the media, which the administration argued was false, given his instructions to Professor Richman. And by pursuing these charges in 2025, the administration wanted to prove their long-held theory that the original Russia investigation was built on corruption and lies by FBI leadership. Okay, so now we need to put on our lawyer caps, and we're all going to become constitutional scholars now. And has been the case with many items during the last 8, 12 years. We're seeing more and more constitutional questions come up. So we're all going to become experts in the Appointments Clause. Now, if you are a friend of the president, if you're favorable to Donald Trump, you might already be familiar with this because it's exactly this clause that one of his cases, the classified documents case in Florida, where the government accused him under the Biden administration, they accused him of retaining classified documents without authorization. That case was dismissed under the same grounds. So it's interesting that those grounds are still available here, and that's what was used to dismiss the cases against James Comey and Letitia James, which in many cases were sort of revenge lawfare cases, you could say. All right, so let's go to the U.S. Constitution, Article 2, Section 2, Clause 2. This is the Appointments Clause, which says this. He, talking about the president, the executive, shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur, and he shall nominate by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for. Okay, so all of these people are what the court and lawyers talk about as superior officers. These are the big letter officers. This is, you have to be appointed by the president and confirmed by the Senate. No other way around it, right? It's that important that those two things have to happen. The clause goes on to say, and for which shall be established by law, right? But the Congress may, by law, so Congress can pass a law, they can vest the appointment of such inferior officers as they think proper in the president alone, or in the courts of law, or in the heads of departments. I think maybe you see where this is going, right? So Attorney General of the United States, appointed by the president, has to go in front of the Senate, has to get approval from the Senate in order to take her job, right? Advice and consent of the Senate. That's what she needs. Technically, it's not approval, but it's advice and consent of the Senate. If they don't consent, then it doesn't happen. But these inferior officers, right, if you're not the Attorney General of the United States, first, I think we need to know, because maybe some of our listeners don't know this. If you look across a map of the United States, if you look up a federal district court map, every federal court district will have an attorney general, right, a head attorney general, and AUSA, an assistant U.S. attorney, for that district. Okay, so it's not the Attorney General of the United States. They're in charge of all the attorney generals. And then each district, for example, here in the Western District of Michigan, you have a U.S. attorney who is appointed by the Attorney General, approved and consented to by the Senate as well. And they serve as the head for just this federal district court area. You have the same thing in the Eastern District of Virginia, where these two cases we're talking about today, the one against Letitia James and James Comey, those take place. And what happens? From time to time, the President of the United States will change. And someone who is the head, for example, we'll use this example, the Eastern District of Virginia, will say, you know what, I was appointed by Joe Biden, I was appointed by a Democrat, I don't think I'm going to be on board with much of what President Trump is going to want to do. You know what? It's a good time for me. I'm going to resign. So they resign as the chief attorney general of that district. Okay, so that's an inferior officer. Typically, they would need to be recommended by the president and approved by the Senate. However, as an inferior officer, the Constitution says that Congress can, by law, so they can pass a law, to vest the appointment of such inferior officers as they think proper, either in the president alone or in the courts of law or in the heads of the departments. Well, my friends, a law was passed. And it's found in 28 U.S.C. section 546. And this is on how the attorney general and the district courts can fill vacancies when the chief or head attorney general of that district resign or die for whatever reason. Right now, there's a vacancy. How do you fill that vacancy? Well, according to the statute, the Attorney General may appoint a United States Attorney for the district in which the office of United States Attorney is vacant. Okay, so the Attorney General can appoint one. The Attorney General shall not appoint as United States Attorney a person to whose appointment by the President that the office that the Senate has refused. Okay, so if the Senate said, well, we're not going to give our consent on this person, there's no back door to appoint that same person just by the Attorney General. In Section C of that statute, it says a person appointed as a United States Attorney under this section may serve until the earlier of either, 1, the qualification of a United States Attorney for such district appointed by the President under Section 541 of this title, or in other words, they're approved by the Senate, or the expiration of 120 days after appointment by the Attorney General under this section. Okay? So they can be appointed only by the Attorney General. That's fine. But it's only good for 120 days. You either got to get ratified by the Senate or your job's gone, right? You can't do that anymore. Now, Section D of that same statute says, and this is the last part, stay with us, if an appointment expires under subsection C2 that we just read, so the 120 days have passed, the district court for such district may appoint a United States Attorney to serve until the vacancy is filled. So that means until the vacancy is filled by the Senate approval process. The order of appointment by the court shall be filed with the clerk of the court. Okay, so here's a unique one of these checks and balances that get very little attention in, our civics classes or even in law schools or in wherever. But if you think about it, there is an important check against executive authority by doing it this way. Okay, the Constitution itself says Congress can make a law about how to do it. They did it. Now the law has to be followed, as it has been followed for years and years. But what happened? In this case, Lindsey Halligan was an aide in the White House to President Trump. Okay, so she was serving side by side with him, helping him out with the things he needed in the White House, whatever. She has a law degree. She did go to law school. She was an insurance attorney before she was appointed by Attorney General Pam Bondi to the Eastern District of Virginia. She had zero prosecutorial experience. Okay, she had zero federal court experience. She'd never been in a federal court. She never served as a prosecutor, not state, not local, not federal, nothing. And let me tell you, there's a lot that you can't just learn on the job. You really do want someone with experience to take those jobs. And it's not a matter of, all the prosecutors in the world are too corrupt. It's impossible to find someone who's competent and honest. That's not the case. No, if you've ever met a U.S. attorney, you know that they operate under very strict rules. If they're prosecuting someone and something comes up, dealing with a U.S. attorney is a very serious matter. They have their reputation to look after. They understand the fact that they need to turn over evidence if there's potentially exculpatory evidence, right? They understand what vindictive prosecution or selective prosecution is. And so when you're trying as president to nail a particular enemy of yours, you will get resistance, not only from U.S. attorneys who politically may be more on your side or on the other side, all of them. And in that case, we're going to see why that happened. In that situation, you're going to see why that happened in this case. And it's, like I said, this is a perfect example of one of the checks and balances that exist in the Constitution. We don't want to give the unfettered ability to the President of the United States to start committing lawfare of his own by appointing prosecutors and saying, go after this person, go after this person. This person really gets my goat, so we need to go after them too, right? We're going to see that that's not allowed. That's not the idea of having the three branches of government, right? You have the legislative, the Congress. You have the president, the executive, right? And you have the courts. So in this statute, those who drafted it understood that there is a delicate balance. So if the vacancy needs to be filled, you can do it for 120 days. But after that 120 days is up, the court gets to choose. The local court gets to decide who the U.S. attorney will be. Okay? And that is designed to encourage the president to appoint people who can pass Senate confirmation. And if he fails to appoint someone who can't get through Senate confirmation in time, well, then he doesn't need that authority right now. We'll give that to the judges, who can use their judgment from the judicial branch. Because in the judicial branch, when you're looking at federal judges, they know the local prosecutors. They know what prosecutors are good, what ones are competent, because those prosecutors practice in front of them. They have firsthand experience, so they can say, okay, the president's screwing this up. They haven't been able to get their nominee appointed. Well, what do you think about Prosecutor Jones? Yeah, Prosecutor Jones, he's in front of us all the time. He's always well prepared. He knows what he's doing. He follows the law. We don't have to overrule him often. He doesn't really lie to us. And, his claims are legitimate. So it's not like we're dismissing his cases left and right. So you know what? We're going to appoint him. And then once the president can appoint someone who gets through Senate confirmation, once that Senate confirmation happens, then they will take their position as U.S. attorney for the district of whatever. In this case, Eastern District of Virginia. All right. Now, Eastern District of Virginia, that's where they brought both of these cases. And there is a reason. If you've ever seen any of the material or podcasts involving John Kiriakou, he had firsthand experience in, I don't know if it was Eastern or Western, but it was in Virginia. And in Virginia, you got a lot of government employees. The people who end up on grand juries or on juries in your case, the judges who you're in front of are very familiar with whistleblower lawsuits. They're very familiar with people who they think are snitches, and it's very hard to be found not guilty of a violation of a lot of federal laws, especially when it has something to do against the State Department, the CIA, the federal government, the FBI. So the federal government loves to bring cases in Virginia for that reason. Okay, and that's where both of these cases were brought. Letitia James is an attorney general in New York. Okay, why are we bringing a case in Virginia anyway? Well, that's why, because they want to secure the most favorable court for them. So it's a way of forum shopping that even the federal government, even the Attorney General of the United States can do. And they do it. And that's why these are both in Virginia. Okay, so there's that important check on power. Well, what happened in this case? Let's take a quick look here. I want to put a graphic on the screen because this is a nice little infographic we have. And we'll be able to show you if you're watching this in video format. Okay, so the Attorney General, as we reviewed, the Attorney General gets the first appointment that it lasts only 120 days. After 120 days, that shifts to the district court who gets to choose. But what happened in this case is you had the original Attorney General who said, you know what? I'm out. And so on January 21st, 2025, the Attorney General, Pam Bondi, appointed Eric Siebert as the interim U.S. attorney. That 120-day clock starts. That 120-day clock ended on May 21st, 2025. So the Attorney General's authority And any work done under that individual would not be valid anymore, right? So the district court exercises its statutory power and reappoints Siebert, right? So the court appoints Siebert. Again, the 120 days is up, goes to the court. Court says, you know what, you're doing a decent job. You stay in the job for now. September 19th, 2025, Siebert resigns. He resigns under pressure. Okay, he was appointed by the Attorney General, Pam Bondi. He was the president's pick. But he resigns after expressing concerns about the viability of charges against Comey, so James Comey, and Letitia James. Right? So he was getting pressure from Attorney General Pam Bondi, President Donald Trump. They were saying, go after them. Take an indictment to a grand jury, get them to vote for the indictment, get them to vote to indict these two people. We hate them. They're awful. We hate what they did to the president. It was lawfare. It was not nice. It was not good at all. You need to do this. And Siebert says, you know what? I understand, but I don't think it's legally viable. I don't think those charges can stand up to scrutiny. He looks at it and says, you know what, I think this might be vindictive prosecution, or this might be selective prosecution, or this might just, there's no evidence here to support the indictment. Okay, it's not a viable case. And when the Attorney General's in a situation like that, sometimes the only thing they can do is resign. Because, I mean, they could, I suppose, eventually get fired, but he was appointed by the court at this time. But here, they're all playing a political game as well. So, September 19th, he resigns under pressure. And President Trump tells reporters, I want him out. Okay, and he goes and gripes about Siebert later. On September 20th, 2025, one day later, next day, President Trump posts a message on social media urging action from Attorney General Pam Bondi and suggesting Lindsey Halligan for the role. So 2 days later, Pam Bondi appoints Lindsey Halligan as interim U.S. attorney. Now, what's the problem with the logic here? Well, the problem is the president and the attorney general already had their first 120-day appointment that they used on Eric Siebert. Okay? The court extended it. Now he's gone. Now, the question, I guess, would be, and the question that was raised at court and that the judge decided on was, well, when there's another vacancy off of a temporary placeholder attorney, the president can just, or the attorney general can just appoint another person for another 120 days, right? Wrong. The statute doesn't read that way. Look, the statute reads, the attorney general may appoint the United States attorney for the district, right, where you would say United States attorney is vacant. And of course, there's the limitation that they can't appoint someone who is refused by the Senate. But they will only serve until the earlier of their qualification by the Senate or the expiration of 120 days after appointment. And if an appointment expires under subsection C2, that 120 days, the district court for such district may appoint a United States attorney to serve until the vacancy is filled. It no longer goes back to the attorney general to appoint whoever they want. That's why this is such an important illustration of a constitutional check or balance that exists both through the Appointments Clause and the enabling statute under 28 U.S.C. 546. Because that's exactly what happened here. The president was pressuring that temporary attorney general to go and indict Comey and indict Letitia James, his very personal enemies, right? It's very clear the president was engaging in lawfare here. Like, the president's not an attorney. He's not an expert on these statutes. He's not an expert on what you can legitimately indict someone for. And as a prosecutor, you're under an obligation to not indict someone if you don't believe there's a good faith argument that they committed a violation of the law. You are prohibited by law from attempting to prosecute someone for that. So the president was asking the attorney general, pressuring the attorney general, the temporary one who was appointed, filling the vacancy, he was pressuring him to violate the law and his ethical responsibility, which could result in him losing his license and never being able to practice law again, potentially. You can't do that. We live in a free society. We have rules. We have a constitution. We have statutes that need to be followed. You cannot just go after your political enemies. That is as unfair as the Obama administration using the IRS to go after religious organizations that didn't line up with their beliefs. It's as unfair as can be. It's an abuse of discretion. It's an abuse of executive authority. So he gets a little riled up there. Okay? So that happens. In September and October, so late September, early October 2025, Lindsey Halligan, acting as the sole prosecutor, secures grand jury indictments against Comey and James. So against James Comey and Letitia James. Now, the case begins. They secured an indictment. Is that a surprise? No. There's a famous saying. You can indict a ham sandwich. As a prosecutor, when you go to secure an indictment, you go into what's called grand jury proceedings. Okay? The person you want to indict, they don't get to participate. They don't get to testify. They don't get to give their side of the story. So you can present to them a very convincing case, especially if they're guilty. However, there are court rules to follow. There are constitutional protections even at the grand jury stage. Okay, we'll go into what some of those are. Let's go into what some of those are, because Lindsey Halligan allegedly did not follow them. So in the particular case of former FBI Director James Comey, you had allegations that she was misstating the law, or she was stating things like, oh, we're going to bring additional evidence too. You got to believe we got even more evidence than this. Saying things like that, you cannot say in a grand jury proceeding, because it's essentially you saying, trust me, bro. And you can't trust me, bro, your way to an indictment. Okay? One of the bigger things that was pointed out by the Comey defense is the judge said, all right, I want to look at the grand jury proceedings transcript because there's allegations that things went haywire here, and we got an attorney general who allegedly isn't even an attorney general. So when the transcript was produced, the judge said, hey, there's a gap. I want the full transcript. And they were like, oh, we gave you the full transcript. Everything you asked for, we gave you. And so there's a 2-hour gap, and it's unaccounted for, and we don't know what happened there. And there could have been anything said during that time period to these grand jurors. And the fact that you can indict a ham sandwich, you can indict anyone. You got to look at these things with really special scrutiny, really strict scrutiny. You really have to scrutinize what goes on in the grand jury proceedings. If you have a prosecutor who's lying or misstating the law or has people in the grand jury proceedings that are not permitted by law to be there, that's a problem. And that was one of the other problems. That was the main problem that the judge focused on in the decision, is that you had Lindsey Halligan present in the grand jury proceedings. She's not lawfully appointed as the attorney general for that district. So you have someone in there who's not lawfully allowed to even be in there. Now, it's not insignificant either that she was the only prosecutor who signed on the indictment, who signed to get that indictment to put in front of a grand jury, and that the grand jury eventually agreed on. The first one she submitted, they didn't agree on count 1, and so they couldn't secure an indictment. She ended up coming back with another draft that only allegedly, right? I don't have the copies in front of me because grand jury materials are secret and they've not been released in this case. But according to the foreperson, he was the only one who signed it, when it should have been there should be a record showing that the entire grand jury looked at it, agreed with it, voted for it, and then the foreperson signs it. But there was no evidence of that. So it was also defective, potentially because of that. And then you can look at it and you can say, well, not bad for a first time, right? This is the first time Lindsey Halligan is ever a prosecutor, and she goes straight to the top as an attorney general for the Eastern District of Virginia. That's like walking into McDonald's as a 14-year-old and getting a job as the comptroller for the McDonald's organization. That's ridiculous. She didn't know what she's doing, which ultimately comes back to bite them all in the rear end. Because there's really only one remedy when something has gone so wrong. And that's what the defense was asking for, was a dismissal of the indictments. Now, when some of these things started coming to light, the Trump administration and Pam Bondi, the attorney general, realized, hey, we got an issue here. There's a problem because it looks like we may not win this. I mean, they were watching the proceedings. They know what was going on in the hearings with the judge in these cases. And so, what do you try to do when the boat's sinking? You slap a Band-Aid on it. You got to try and patch the hole in the hull, and that's what they did, right? So there was a letter filed with the court by the Attorney General saying, hey, whoa. It's all good. Even if she wasn't lawfully appointed, I'm going to ratify everything she did. She was doing that. She was an attorney. She's an attorney for the government. That's really all that matters here. So everything she did, I'm going to stand by it. I'm going to put my rubber stamp of approval on it as Attorney General of the United States and call it good. Well, there's a problem with that. How can Attorney General Pam Bondi know what was going on in the grand jury proceedings in order to ratify it if the full transcript isn't there? The doctrine of ratification doesn't allow that. So I want to read from the Comey decision here because there's a great little paragraph on ratification. Ratification is the affirmance by a person of a prior act which did not bind him, but which was done or professedly was done on his account. And this comes from a treatise on that. In effect, the doctrine reaches back and makes it so that a formally unauthorized act was authorized from the get-go. But for ratification to be effective, the principal must have had the authority to authorize the action both when the action was initially performed by the agent and when the act was affirmed by the principal. The Attorney General lacked that authority at both points here. It goes on to say, and this is the judge speaking, I have already concluded that Ms. Halligan's original appointment was invalid and that the Attorney General's attempt to retroactively bestow special attorney status on her was ineffective. As a result, the Attorney General could not have authorized Ms. Halligan, who was not an attorney for the government at the time, to present Mr. Comey's indictment to the grand jury on September 25th. The implications of a contrary conclusion are extraordinary. It would mean the government could send any private citizen off the street, attorney or not, into the grand jury room to secure an indictment so long as the Attorney General gives her approval after the fact. That cannot be the law. Now, specifically in the case of against James Comey, the question then becomes, okay, if this is getting dismissed, what kind of a dismissal is it? Is it with prejudice or is it without prejudice? And it has nothing to do with racial tensions. With or without prejudice means this. If the case is dismissed without prejudice, the judge would be willing to hear the case again if it's brought again through the correct procedures, following the correct rules, constitution, statutes, etc. Okay? By an attorney general who has authority to do it. That would be without prejudice, right? If a judge dismisses a case with prejudice, it means, no, this was so egregious, I won't even ever hear another case based on these specific allegations. It's too bad. It's just too awful. And there are some circumstances that the courts will do it with prejudice, some circumstances where they'll do it without prejudice. In this case, the judge states, ultimately, I believe the Supreme Court's appointment clause jurisprudence provides the answer to the with or without prejudice question. He referenced a couple of other cases where, in both of the cases, the court simply unwound everything that the unlawful prosecutor had done and put everybody back in the same position they were before the whole mess started. He says, I will do the same here. I will invalidate the ultra vires, that means outside the statute, ultra vires acts, the unlawful acts, performed by Ms. Halligan, and dismiss the indictment without prejudice, returning Mr. Comey to the status he occupied before being indicted. Okay? Now, it might sound like, well, they're just going to refile and he's going to be in the same position again, so why go through this whole mess? Well, my friends, there's another magical little piece of law called a Statute of Limitations. And what a Statute of Limitations does is it says, if somebody breaks the law and you want to prosecute them for it, you got to do it within a certain period of time. For some crimes, there is no statute of limitations. It could be your whole life. Typically, murder, right? That's one thing where if you ever murder someone, you don't really get away with it just because enough time goes by without being caught. But there are certain offenses, tax offenses, property things, where there is a statute of limitations. So the prosecutor has to bring the case, they have to file it before a certain time. They don't have to get a resolution on it before a certain amount of time, but they do need to bring the charging document before that statute of limitations runs out. Well, in this case, the court already determined that the statute of limitations for these alleged offenses expired on September 30th, 2025. That's right. A mere 2 months ago, that statute of limitations expired. There's no new indictment by someone with authority as Attorney General. So, de facto, by default, it's with prejudice. They can't bring another one against him for that. Now, will they try and find something else he did that's within the statute of limitations? Will they try and pressure another prosecutor to do it? They may try. But like I said, it's not insignificant that Lindsey Halligan was the only person to sign off on this. Nobody else in the Eastern District of Virginia's U.S. Attorney's Office was willing to sign their name on that indictment. They were not willing to join as an attorney in that case. They were not willing to put their name and their ethics and their law license and their reputation on the line to do this. This is a very, very significant fact. In fact, it may be that they struggle to find someone who's going to do what the president wants in this regard from now on, because, prosecutors, they're not just going to want to be a prosecutor for 4 years during a lame duck presidency. No, they're going to want to have a decent career. They may want to go on to other and better things at some point, but most of them don't want to be limiting themselves to just 4 years. But at the same time, like Eric Siebert, if you're in a position where it's my road or the high road, and my road is you're going to do something unethical that puts your law license at risk, well, you got to take the high road. That's the long and short of it, right? We have a dismissal of these things. And there's another really important part. There's another really important point to note here. In the decision, we went through the decision to review it. There's a lot of law and a lot of statutory citations, case law that's referred to. In this case, it's also significant, I think, that when we look to the history of the case, the factual background, right? We're looking at page 4 of the Comey decision today. And it goes sort of through the history of who gets appointed. Right, Eric Siebert gets appointed under the 120-day designation. He gets reappointed by the judges who continue that role. September 19th, Mr. Siebert informed colleagues of his resignation. According to news reports, Mr. Siebert recently expressed concerns to senior Department of Justice officials about the viability of pursuing charges against Mr. Comey and New York Attorney General Letitia James. His resignation came hours after President Trump told reporters at the White House he wanted Mr. Siebert out. The very next day, Trump posted and later deleted on social media the following. He was thinking this was a direct message, probably. Pam, I have reviewed over 30 statements and posts saying that essentially same old story as last time, all talk, no action. Nothing is being done. What about Comey, Adam Shifty Schiff, Letitia? They're all guilty as hell, but nothing is going to be done. Then we almost put a Democrat-supported U.S. attorney in Virginia with a really bad Republican past. A woke rhino. Right, anyone who does something Trump doesn't like, he gets labeled as a woke rhino, Republican in name only, who was never going to do his job. That's why 2 of the worst Dem senators pushed him so hard. He even lied to the media and said he quit and that we had no case. No, I fired him. And there is a great case, not great cases in caps, and many lawyers and legal pundits say so, which means talking heads on TV. That's who the president gets his legal advice from time to time. No, I fired him. It's a great case. And many lawyers and legal pundits say so. Lindsey Halligan is a really good lawyer and likes you a lot. Now, why would you add likes you a lot? Like, who cares? I don't care if I'm going to hire someone, I don't care if they like me. I care if they're going to do a competent job, especially if we're hiring an attorney general for the Eastern District of Virginia. We can't delay any longer. It's killing our reputation and credibility. They impeached me twice. Okay, let's be clear. We'll get back to that. They impeached me twice and indicted me 5 times over nothing. Justice must be served now. President DJT. All right, so that was a post Trump made. They impeached me twice. They, talking about Eric Siebert, did not impeach President Trump. He was impeached by the House of Representatives twice. Okay, that was a whole different branch of the government. Now because he's got this complex of this victim mentality, he thinks anything that happens against him is a big conspiracy against him and not the consequences of his actions or of things that he's done. Okay, but it seems a little misplaced. But that's how he speaks to his Attorney General of the United States. And they kiss his ass every meeting. Oh, thank you, President, for your leadership. Thank you so much for your leadership. This is not leadership. This is a crybaby. This is a bully. This is a spiteful and vengeful little man. This shows it. This is Exhibit A right here. If he had any leadership at all, he would say, you know what? We don't want to waste our resources on some vendetta. I won those things. I'm winning still. Let's go get drug traffickers. Let's go get, pedophiles. Let's go prosecute pedophiles and end human trafficking and the victimization of young girls. How about we do that and focus our efforts on that? Instead, he's worried about his ego. Yikes. So I think it's important to note that whole, whether it was a tweet or a truth, whatever it was, shows up in the decision as well. Here the judge says less than 48 hours after that, the Attorney General issued the order authorizing Lindsey Halligan to be the interim U.S. attorney for the Eastern District of Virginia during the vacancy in that office, which they can't do under any circumstances. Even if she did have the authority, it'd be limited to 120 days. This is what the Trump administration tried last time. I'll remind you, because since I practice in immigration law, we saw this happen with U.S.C.I.S., with DHS. Chad Wolf was appointed. Others were appointed to be the acting director of whatever's called. Well, it was a violation of the federal vacancies filling. They were filling the vacancies in violation of the Federal Vacancy Reform Act, right? So everything that they did, which was chaos, eventually gets ruled null and void because they never had authority to do it in the first place. But here, and Pam Bondi ought to know better. She's an attorney. She's the Attorney General of the United States. She should know she can't do that. Because it's the same thing that got Jack Smith excluded and removed as special prosecutor against Donald Trump in Florida. Okay, in the classified documents case. In that case, this is the argument that they brought. No, a special prosecutor has to be approved by the Senate, appointed by the president, approved by the Senate, because they're not an inferior officer, they are a superior officer. And it's the same section of law. And at the time, you heard a lot of people on the left say, well, this is unprecedented. We've always done it this way. It's always happened this way. Okay, well, maybe the judge in that case. Yeah, in that Florida case, the Trump confidential documents case that took place in Florida, Judge Eileen Cannon, a Trump appointee who is presiding over that case, that many saw as a potential conflict of interests. Well, what did she rule? She said Jack Smith, yeah, he being appointed by the Attorney General, but that office is one of these bigger offices, and there's actually no statute that says that the Attorney General can appoint a special counsel on their own. And he didn't pass through Senate approval process, so he was invalidly appointed, and the result there is dismissal. Okay, and that case was dismissed. Okay, so the same thing that saved Donald Trump with Judge Eileen Cannon down in Florida, doomed the case against James Comey. So what's good for the goose is good for the gander, it turns out. And again, the main issue there was that there was no statute that authorized it, right? We pointed at 28 U.S.C. 546 that says, yeah, in a vacancy in the Attorney General's office of a district, they can be filled this way. There's nothing that says anything about special counsel. So all those are going to be really suspect right now if somebody gets appointed without approval of the Senate to do something like that. But that, I mean, these are some really, really significant cases because what does it mean? It means James Comey can't be prosecuted for this same alleged incident of lying to Congress. And I think the reason Eric Siebert had a problem with it, because we looked into this quite a bit. When you want to say that somebody lied to Congress, you got to point to a specific question that they were asked and a specific answer that they gave, and that the answer was given with the intent to deceive, right? Lying is not just giving misinformation. There's a distinction. If I'm lying to you, I'm trying to get you to believe something that's not true. I know it, you don't know it, but I'm trying to convince you. I intend to deceive you. Now, if you ask me and I'm just saying stuff because I'm in a hurry and whatever, and I say something that's inaccurate, but I have no intention in my heart or in my mind to deceive you, that's not lying. Okay, so it's a distinction there. So you got to point to something specifically. And they were using this dialogue between Ted Cruz, the famously ashamed on the Tucker Carlson interview, the famously ashamed Ted Cruz, shameful for sure. And he's asking a compound question. Well, any lawyer, and Ted Cruz has a law degree, so I don't know if he has a license to practice law, but he has a law degree if I'm not mistaken. Any lawyer knows you don't ask compound questions. In fact, if you're asking a compound question during an examination in court, the judge will stop you and say, hey, break that question up. Because the client, you could say, hey, what do you like more, the color red or is the color blue? Or do you like red with blue or yellow or green? Isn't that true? Well, that's a compound question and it's not even logically formed, right? There's no way to answer that question correctly and for you and I to both understand what the one and only meaning of that answer is. So you don't ask compound questions. But that's exactly what Theodosius Cruz did during this hearing where they're alleging that Comey was lying to them. So it was a terrible case. And it's probably one of the reasons Eric Siebert was like, we don't have anything here. This is not legitimate. It's a waste of our time. It's a violation of my ethics. In order to bring this case, I got to resign. That's the only option he had. Okay, so when we look at these things, it's real important to know that there's a delicate balance in power. The best thing that the founders did in the Constitution is to take the immense power of a government and divide it up and make sure that one branch of the government can stop another branch of the government if they start getting too big for their britches, as we might say. If they start abusing their authority. If they start becoming tyrannical. And why did the founders do that? Because they lived under a king. They lived under a despot. They lived under someone with complete executive authority who could command the parliament, he could command the military, he could command his prosecutors to bring anyone he wanted, and he could throw them in jail. You did not have the right of habeas corpus. You did not have the right to a trial by your peers. You did not have any of these things. So the founders saw this and they said, we got to take this power and divide it up. It's the only way we're going to be able to operate because we men are not angels. We're not fit for it ourselves. There need to be limits on it. It was the best thing they ever did. And what we see in this decision denying or dismissing the indictments in these cases, I mean, that's a perfect example of it. I love it. It's a beautiful example of it. And now reviewing the indictment or the order dismissing the indictment against Letitia James is very much the mirror image of that dismissed the indictment against James Comey. One difference, though, in this case. Again, it was dismissed without prejudice, meaning a prosecutor could bring it again. However, the order clearly states The order clearly states that the power to appoint an interim U.S. attorney for the Eastern District of Virginia, pursuant to 28 U.S.C. 546 during the current vacancy, lies with the district court until a U.S. attorney is nominated by the president and confirmed by the Senate. So, can they go after Lindsey Halligan again? Well, the bad news for Letitia James is that the statute of limitations for that is more like 10 years, not 5 years like it is in the James Comey case. However, the property in question lies solidly in the Eastern District of Virginia. So they have primary jurisdiction. It would have to be brought again in the same jurisdiction, and you would need a U.S. attorney to bring it. Lindsey Halligan is an invalid U.S. attorney. She can't do it. She can't bring anything against her as long as she stays in that office. In fact, anything Lindsey Halligan does not have the force of law in the Eastern District of Virginia. She essentially lost her job when she lost this case. So the court, as stated in the Comey order and in the Letitia James order as well, the district court will be choosing the next attorney general. And if that attorney general, the U.S. attorney for the District of the Eastern District of Virginia, if that attorney doesn't think there's a case, they won't bring a case against Letitia James. And if they get pressured by the president, well, the president can't fire them from the job. The only alternative the president has at that point is to find a nominee that can pass Senate approval in order to replace the person who's there now, or who ends up replacing Lindsey Halligan, the incompetent, l'incompétent. All right, so there is a statute of limitations. It's 10 years. These documents were filed, 2020? Looks like my information is saying here August 17th of 2020. So in 2030, the statute of limitations will pass. But we'll see. We'll see what happens if another case is even brought against here. This is a very significant victory either way. It states who has the authority to appoint the U.S. attorney for the district under these circumstances. And it reinforces a constitutional protection and a statutory protection that limits the presidential appointment power to 120 days. All right, I want to thank you for joining us today. Hope we learned a lot. It's an exciting case, has to do with the Constitution, and now we're all legal experts on the Appointments Clause and on 28 U.S.C. 546, which states how U.S. attorneys' vacancies can be filled. As always, we're brought to you by Prima.Law. Prima.Law is immigration case management. Okay, we're primarily for immigration attorneys and immigration professionals. However, we are a robust legal case management system. So if you need to track cases, right, you need a smart table that looks kind of like Monday.com or that looks like Airtable, a smart table that you can configure. You can tag different things in order so you can look at a list of all your cases and you can say, you know what, show me a list of all of the cases that are family petitions or that are citizenship petitions or that are a divorce petition or a criminal defense petition of this type. You can tag all of your cases so you can easily sort through them, find them, track their status, make assignments to your staff, make assignments so that cases keep moving along. We have all the features you need, like a client portal, so clients can communicate and upload documents directly to your case. For those immigration practitioners out there, we have a lot of immigration-specific tools, forms, 150 case templates with checklists and steps to go through to complete each case. Very robust as well. Take a look at those. And e-payments, right? You need to collect payments. You want to do that electronically. It's safer, it's more secure, it's more reliable, less problems for slippage, things like that. Find a free 15-day trial, as always, at www.Prima.Law. Thank you for joining us again. If you've enjoyed the content, please like and subscribe, share it with a friend. We'll be here.